Welcome to EUPrivacyForAll, Session 18 on GDPR, Article 18, Right to Restriction of Processing. Article 17a has been renumbered Article 18 on the right to restriction of processing. It lays down the right to obtain from the controller the restriction of processing, where, first, the accuracy of data would be contested by the data subject, and for a period enabling the controller to verify the accuracy of the personal data. Second, the processing would be unlawful, and the data subject opposes the erasure of the personal data, requesting instead the restriction of their use. Third, the controller no longer needs the personal data for the purposes of the processing initially identified, but only in the frame of the establishment, exercise, or defense of legal claims, or finally, where the data subject has objected to processing. Where processing of personal data has been restricted, such personal data shall only be processed with the data subject's consent, or for the establishment, exercise, or defense of legal claims, or for the protection of the rights of another natural or legal person, or for reasons of important public interest of the Union or of a member state. The third paragraph of Article 18 lays down that a data subject who has obtained restriction of processing shall be informed by the controller before the restriction of processing is lifted. Recital 67 provides interesting provisions regarding what it concretely means to exercise the right to restriction of data. A controller will have, for instance, to temporarily move the selected data to another processing system, or making the selected personal data unavailable to users, or finally, temporarily remove published data from a website. In automated filing systems, the restriction of processing should in principle be ensured by technical means. And the fact that the processing of personal data is restricted should be clearly indicated in the system. In Recital 156, it is reminded that Member States should be authorized to provide specifications and derogations to this right. Article 4.3 of the GDPR defines what is the restriction of processing. It concretely means the marking of stored personal data with the aim of limiting their processing in the future. Articles 13.2b and 14.2c remind that the controller has the obligation to inform the data subject about this right, and Article 58.2g makes clear that supervisory authority have corrective powers regarding the obligation for a controller to rectify or erase personal data or restrict the processing of such data. The directive does not provide any kind of individual right to data restriction, but the right to the blocking of data. In Article 12b and c, it is mentioned that there is a right to obtain from the controller as appropriate the rectification, erasure, or blocking of data, the processing of which does not comply with the provisions of the directive, in particular because of the incomplete or inaccurate nature of the data. What should accountable data controllers get prepared for? First, pay attention to this new right for data subject to ask for restriction of processing based on the lack of accuracy of data, the specific ask of a data subject in case of unlawfulness of processing, the establishment, exercise, or defense of legal claims when data is not needed for any kind of other purpose, the pending verification of the validity of a data subject's objection. Controllers will have to indicate the restriction in the system using automated means. They will also have the obligation to inform data subjects before lifting the restriction. Controllers will have to process data in a restricted way only with the data subject's consent for the establishment, exercise, or defense of legal claims, for the protection of the rights of another natural or legal person, or for reasons of important public interest in the Union or for member state law. Concretely, it means that data controllers will temporarily be moving the selected data to another processing system, or making the selected data unavailable to users, or finally, removing temporarily data from a website. Once again, member states can provide specifications and derogations to this right. It will be now interesting to check what will be member states or union laws and the EDPB or court's guidance on concrete implementation of this right.